Hi, good evening, everyone. A very, very warm welcome to this another session of Perspectives. We have been running this session every month, and we have been getting very, very encouraging feedbacks from all of you. So, thank you so much for your encouragement, your response to this initiative from Canara Robeco. As you are aware, that in Perspectives, we actually invite various host of speakers from various different fields. And if you recall, I think we have actually had speakers talking about in terms of their markets theory. We have speakers who have been talking about ikigai. We have been talking about speakers talking about even geopolitics and so on and so forth. So the entire idea is to actually have discussion on various topics, on diverse topics, as much as we can. And, you know, then, just to help you in terms of your business. And today, I think we are in a very, very special call today because we have a very special guest today, and he's going to talk about legacy planning. This is something I know for sure that we have been getting a lot of feedback from all the partners. I think this is one thing their investors are looking at. This is an opportunity for them to add value. This is also, from their investors' perspective, also it's one of the very important aspect. So, and this is not about, when you talk about legacy planning, it is not about, it goes beyond in terms of the wealth creation, because of course, in that part, we all are actively helping them as a distributor of the financial products, but it is about how your assets, value, and intentions are passed on smoothly, tax efficiently, and without any conflict. So that again remains a very, very important part that all our investors, we ensure that their wealth reaches the right people at the right time and in the right manner. And to answer some of these aspects, to enlighten us, we have a very special guest, Mr. Deepak Jain. Of course, he's an authority on this subject, I can tell you. And I'm sure lot of you, maybe knowing him, would have interacted with him and attended some of his sessions. And we are very, very pleased, privileged to have Mr. Deepak. So, very warm welcome, Deepak.
Thank
And
you very
thank you
much,
very
sir.
much for accepting our
Thank you very
invitation.
much. It's a pleasure. It's a pleasure, sir.
Thank you. So just to introduce Deepak, he is a founder director of American Academy of Financial Management. He is also the founder director of Next Gen Estate Planning Solution. He is a renowned estate and succession planning expert, author of 26 books on finance, wealth management, and estate planning. And that's why I'm saying he's authority on the subject. So we are really very privileged to have him here. As a financial trainer, he has led AAFM India to train over more than 45,000 individuals and 30,000 wealth managers in the last few years, establishing it as a leading financial training organization in India. So he's a highly accomplished and renowned financial expert with more than 25 years of experience, founder director of American Academy of Financial Management, and the managing director of Next Gen Estate Planning. So with this, again, a very, very warm welcome, Deepak, and we all look forward to your wisdom and to hear your perspectives in terms of the legacy planning. So, with this, over to you.
Thank you. Thanks a lot. I'll just share my screen and we start the session. Okay. So, good evening, everyone. It's a pleasure to connect with all of you on this platform. And when I start this session on inheritance and succession planning, I always ask a question, and I'll ask you the same question. And question is fairly simple. And question is, if you die today, what would you leave behind for your family and children? An inheritance or a mess? I again repeat. If you die today, what would you leave behind for your family and children? an inheritance or a mess? Will your wealth be a source of joy for them or source of problem? In Hindi, it's better put, आप अपने बच्चों के लिए संपत्ति छोड़ोगे या विपत्ति छोड़ोगे, right? Because I know what you want to leave. I know all of you want to leave inheritance, properties, joys, but most people, what do they leave? They leave a mess for their children to sort out. And this session is all about how to actually leave an inheritance, not a mess for your children. By the end of the session, you will know at least some basic things to do to avoid that mess for your children. Now, as uh, Gaurav said, that wealth management is part of three things. When you do three things for your clients, then you are doing wealth management. And what are those three objectives of wealth management? First is wealth enhancement objectives. I should work on enhancing my wealth, accumulating my wealth, growing my wealth. Second is wealth preservation objective, wealth protection objective, wealth safeguarding objective, wealth ring fencing objectives. And lastly, it is wealth transfer objectives. What happens to this wealth after me? As a wealth manager, you should advise your client on all three of them. But most advisors, wealth managers or wealth advisors, they concentrate only on wealth enhancement and they ignore protection and transfer of wealth. Although protection and transfer, if not more important than enhancement, are at least as important as enhancement of wealth. I'll give you an example. You have a client whose net worth is, say, 5 crore rupees. Now, first objective of this person could be how to convert this 5 into 10. So he's more concerned about enhancement of wealth. You have another client whose current net worth is, say, 85 crore rupees. Now, out of these three, enhancement, protection, and transfer, what do you think would be his first objective? And you can write that down in the chat box. Will it be enhancement, protection, or transfer? What do you think? What, according to you, would be most probably the objective of such a client? It is protection of wealth. And what do you talk to this person when you meet? How 85 will become 90? So there's a disconnect between what you are talking and what is his primary objective regarding his wealth. Please remember, all your clients do not have wealth enhancement as their primary motive. Many of them could have protection and transfer. When I'm talking about wealth protection planning, and listen to this very carefully, when I'm talking about wealth protection planning, I am not limiting myself to the insurable risks which my client's wealth faces. There are certain risks which can be transferred to the third party by buying insurance and paying premiums. I'm not limiting myself to this. Like risk of dying early, risk of meeting an accident, risk of having a health hazard, risk of your assets being subject to fire, burglary, theft, etc. All of these are insurable risks. I am not also limiting myself to the environmental risk which my client's wealth faces. There are certain risks coming to the client's life from the environment, like stock market falling, interest rate rising, economy going into recession, Trump being sworn as a president somewhere. All of these are risks which are environmental in nature. When I am doing wealth protection planning, I am including risks which are neither environmental nor insurable. And just to sensitize you that such kind of risk exists, I'll give you an example. There was a client of mine who had a net worth of more than 100 crore rupees and he had only one son. What he did was, and maybe rightly so, he created a will in favor of his only son. And within 2 years of creating the will, this person died. After his death, the will was successfully implemented and his only son inherited this 100 plus crore rupee wealth. And everything looked fine. for the next 8 months. Because as soon as 8 months got over, son's wife applied for a divorce. And as alimony, she claimed 50% of this 100 crore rupee wealth. And courts gave her. Is this a risk? Because none of us, let me repeat again, none of us want our wealth to go to any in-law, whether that's a son-in-law or a daughter-in-law. I'm not gender biased. All of us want to it to go to whom? All of us want it to go to whom? Our daughters and sons. And this unintended recipient of your wealth is called a predator. And I've been in this business of wealth protection and transfer planning for last 13 years. I am yet to meet an individual or family which does not have a predator or a potential predator, which does not have a predator or a potential predator. And what most of you are thinking? In my family, there is no predator. I am lucky to have a family where there is no predator. My question is, or my observation is, the only reason you cannot find a predator in your family today is only one, and the reason is you are alive. You are alive, protecting your wealth and your family. Just imagine you are not there in this world. Who all can be predators? लिस्ट बनेगी लिस्ट एक दो नाम नहीं होंगे there will be a whole list of people who can be potential predators and it is your job to protect your wealth against such potential predators. That is wealth protection planning and I'll come back to this during this session, but I just wanted to tell you there are things which you don't imagine can happen and which can be a threat to your wealth. So this session is all about wealth transfer planning. How do I transfer my wealth to the next generation? And we'll be talking about that in this session. Wealth transfer planning is also called as estate planning. And whenever I start a session on estate planning for common people, you all are very learned people, common people, I have to first explain to them this is not about real estate planning. Because this word estate is common between real estate and estate planning. People confuse it with real estate planning. So let's first understand what makes up your estate. What is actually your estate? When the definition says everything which you own today is your estate, everything which you will own on the date of your death is also your estate, and everything which you will own after your death is also part of your estate. जो कुछ आपके पास आज है वो आपकी एस्टेट है, जो आपके पास डेथ वाले दिन होगा वो भी एस्टेट है, और जो डेथ के बाद मिलेगा वो भी आपकी एस्टेट है. बट माई क्वेश्चन हियर टू यू इज लिटिल डिफरेंट. माई क्वेश्चन टू यू इज, डू यू नो what do you own today? Do you really know what do you own today? How many of you know what you own today? Just type a Y in the chat box. How many of you know what you own today? If I give you a plain piece of paper and I ask you to write the names of all the assets you have, how many of you can fill that list completely? 99.9% people in this world do not know what they own. And most probably, you also belong to that group of people who don't know what they own. So let me first prove to you that you do not know what you own, right? And and listen to this carefully. There was a person who was a businessman, and all of you are businessmen or businesswomen. He gave his business to his elder son through his will. Post his death, his elder son inherited this business of his. And because he did nothing, his younger son got hold of his mobile phone number and email ID. Now, what will happen? Business went to the elder one, and younger one gets the mobile phone number and email ID. What will happen? Either both brothers would start fighting, or business would get transferred from the elder to the younger. Yes or no? But the question is, when I ask you to create your will, how many of you would write in that will, after my death, my mobile phone number goes to this person? My email ID will go to this person. Is your mobile phone number an asset or not? Is your mobile phone number an asset or not? What is an asset? Anything and everything that can be converted into money is an asset. And in today's world, a normal person has four kinds of assets. First is called physical assets: land, building, machinery, jewelry, gadgets, whatever you call it. Second is called financial assets: shares, mutual fund, bank account balance, right? Your saving accounts, etc., etc. Third, which are becoming very, very important today, they are called digital assets. Digital assets: mobile phone number, email ID, website URL, domain hosting, right? And there's some exotic ones which you will miss, like credit card points, credit card points, miles on an airline. Are they not assets? And lastly, there will be some intangible assets: your relationships, your trademarks, your logos, your patents, your IPRs, your copyrights. And until you make a complete list of all four of them, you will not be doing justice to your estate. The first step in estate planning is know your estate. Know what you own. And most people do not know what they own. I'll give you another example of things which you don't know you own. It's called tissue on ice. The word they use is tissue on ice. Have you heard of this term? Tissue on ice? Tissue on ice? So, what is tissue on ice? I'll give you an example of a tissue on ice. When
So
your child was born,
Deepak ji, there is a request coming in. If you
yeah,
can just keep it in a little English,
okay, I'll
combination
do
of
that.
Hindi and English. Yeah,
तो
thank you.
आपने ये वर्ड सुना है टिश्यू ऑन आइस? टिश्यू ऑन आइस क्या है? I'll give you an example जो उससे पता चलता है कि टिश्यू ऑन आइस क्या होता है. When your child was born, you froze their stem cells for 99 years. आपने उनके स्टेम सेल्स को फ्रीज करा दिया था 99 ईयर्स के लिए. इज दैट नॉट एन एसेट? क्या वो एसेट नहीं है? सो मोस्ट पीपल डू नॉट नो व्हाट दे ओन. दे नीड द सर्विस ऑफ अ प्रोफेशनल लाइक मी. मुझे बताओ मेरे पे क्या क्या है. इवन दैट थिंग पीपल डोंट नो. एंड और जो पहला स्टेप एस्टेट प्लानिंग का वो यही है, पहले पता करो कि मेरे पे है क्या क्या, जो उसका मैं मालिक हूं, मैं ओनर हूं, जो ट्रांसफरेबल है, तभी तो एस्टेट प्लान बनेगा. राइट, चलिए अब आगे चलते हैं. What is estate plan? Estate planning is a systematic plan to distribute one's estate according to one's wishes in future. जब आप एक सिस्टमेटिक तरीके से अपनी एस्टेट के डिस्ट्रीब्यूशन का प्लान करते हो अपनी डेथ के बाद, उस प्लानिंग को एस्टेट प्लानिंग कहते हैं. एंड द अल्टीमेट पर्पस, अब इसको ध्यान से सुना इस बात को. एंड द अल्टीमेट पर्पस ऑफ एस्टेट प्लानिंग is to fulfill the estate owner's wishes as closely as possible. As a estate planner, मैं एक ही व्यक्ति के लिए काम करता हूं जिसकी एस्टेट है. आई एम देयर नॉट टू क्वेश्चन हिज मोटिव्स बट टू इम्प्लीमेंट हिज मोटिव्स. मैं ये नहीं पूछता कि तुम अपने बड़े बेटे को क्यों दे रहे हो, छोटे को क्यों नहीं दे रहे, अपनी बेटी को क्यों दे रहे हो, बेटे को क्यों नहीं दे रहे. मेरा वो काम नहीं है. मेरा काम वो है कि वो जो चाहता है या चाहती है वो ही हो, चाहे वो जिंदा रहे चाहे वो जिंदा ना रहे. That's my job as a estate planner, right? And I'm very proud of my job as an estate planner because I make people's wishes come alive after they are dead. That's the job I do. Right? अब आपसे कुछ क्वेश्चंस पूछते हैं ये जानने के लिए कि क्या आपको एस्टेट प्लानिंग करनी चाहिए या नहीं करनी चाहिए. शुड यू डू एस्टेट प्लानिंग और नॉट? राइट. तो मेरे हर एक क्वेश्चन के दो ही पॉसिबल आंसर हैं, एक है यस और एक है नो। अगर आपको आंसर यस लगता है इस क्वेश्चन का, तो आप वाई टाइप कर देना चैट बॉक्स में, खाली वाई। और अगर आपको आंसर नो दिखता है तो आप एन टाइप कर देना। तो आपका अगर आंसर यस आई वांट दिस टू हैपन, यस आई वुड लाइक दिस टू हैपन, यस आई वुड एंश्योर दिस हैपन्स, यस आई विल ट्राई दिस हैपन्स, तो आप वाई टाइप करोगे। अदरवाइज आप एन टाइप करोगे। क्वेश्चन सुनिएगा, ध्यान से सुनिएगा क्वेश्चन। पहला क्वेश्चन है, डू यू वांट टू हैव फुल कंट्रोल ओवर योर प्रॉपर्टी वैल्यू और लाइफ? क्या आप चाहते हैं कि आपकी संपत्ति पर आपका ही अधिकार हो जब तक आप जिंदा हो? कितने लोग चाहते हैं? ऑल ऑफ अस वांट दैट आर प्रॉपर्टी रिमेन्स अंडर आर कंट्रोल टिल वी आर अलाइव। व्हाई? क्योंकि जो आपका कंट्रोल है आपकी प्रॉपर्टी पे, यही आपकी फाइनेंशियल सिक्योरिटी है। और जो लोग इस कंट्रोल को छोड़ देते हैं अपने जिंदा रहते हुए, वो इस दुनिया के सिंघानिया बन जाते हैं। आप सबने रेमंड का केस सुना है। फादर ने अपने बेटे को कब 1,000 करोड़ 1,000 करोड़ रुपीस के शेयर्स दिए, जो 33% स्टेक था रेमंड्स का। आज कहाँ है फादर? आज कहाँ है फादर? ऑन द रोड। नेवर एवर लीव कंट्रोल ओवर योर प्रॉपर्टी while you're alive, because this control of yours over your property ensures your financial security. एक मैसेज है जो मैं बार बार अपने सब पार्टिसिपेंट्स को देता हूं और आपको भी दूंगा। तो मैसेज बड़ा सिंपल है। मैसेज है, लव एवरीबडी इन दिस वर्ल्ड, लव देम एज मच एज यू कैन। दुनिया में सबसे प्यार करो, जितना कर सकते हो उतना करो, पर किसी से भी अपने से ज्यादा प्यार मत करना। सबसे ज्यादा प्यार किससे करिए? अपने आप से। जो व्यक्ति अपनी सुरक्षा नहीं कर सकता, वो दुनिया में किसी और की कर भी नहीं सकता। नेवर एवर लीव कंट्रोल ओवर योर प्रॉपर्टी while you're alive। सेकंड क्वेश्चन जो आपसे पूछना है, मुझे बताइएगा यस और नो में। इन केस यू बिकम इनकैपेसिटेटेड और डिसेबल्ड, वुड यू स्टिल लाइक टू टेक केयर ऑफ योर सेल्फ एंड योर फैमिली मेंबर्स? सपोज आप इनकैपेसिटेट हो गए, आप कोमा में चले गए, पैरालिटिक हो गए, मेंटली अनसाउंड हो गए, आपको डिमेंशिया हो गया, पार्किंसन हो गया। ऐसे सिचुएशन में भी क्या आप चाहोगे कि अपने और अपनी फैमिली का कम से कम फिनेंशियली तो मैं ध्यान रख पाऊं, फिजिकली तो नहीं रख पाऊंगा? कितने लोग रखना चाहेंगे? रख पाएंगे या नहीं, वो अलग बात है, रखना चाहेंगे वर्ड। हाउ मेनी ऑफ यू लाइक दैट टू हैव? जस्ट टाइप अ वाई इन द चैट बॉक्स। आई वांट एवरीबॉडी टू पार्टिसिपेट। बताइए बताइए, अगर आप चाहते हैं ऐसा, पुट अ वाई इन द चैट बॉक्स। ऑल ऑफ अस वांट टू डू दैट। ऑल ऑफ अस वांट टू डू दैट। Now comes my most important question in this series of questions, and that is, do you want to give what you want, to whom you want, the way you want, and when you want on your death? क्या आप चाहते हैं कि आपके बाद आपकी संपत्ति उसी को मिले जिसको आप देना चाहते हैं, उसी टाइम मिले जिस टाइम आप देना चाहते हैं, उतनी ही मिले जितनी आप देना चाहते हैं, और उसी तरह से मिले जिस तरह से देना चाहते हैं? That means you not only want to keep control over your property while you are alive, जीते जी तो अपनी प्रॉपर्टी पे अपना कंट्रोल रखना चाहते ही हो, अपनी डेथ के बाद भी वो कंट्रोल नहीं छोड़ना चाहते। अपनी मृत्यु के बाद भी चाहते हो कि मेरी इच्छा से बटे, जिसको मैं देना चाहूं उसी को मिले, उतना ही मिले, उसी तरह मिले और उसी समय मिले। राइट? अब मेरा आखिरी क्वेश्चन इन सीरीज ऑफ क्वेश्चन में, वी वांट टू एंश्योर अ इजी पीसफुल ट्रांसफर ऑफ योर वेल्थ टू द नेक्स्ट जनरेशन। क्या आप चाहते हैं कि आपकी संपत्ति आपकी अगली जनरेशन पे आसानी से चली जाए, बिना उनका टाइम खराब करे हुए, बिना उनको किसी लॉयर से मिले हुए, कोर्ट जाए हुए, फाइनेंशियल इंस्टीट्यूशन में जाए हुए, आसानी से और शांति से, बिना उनके आपस के झगड़े कराए बिना, बिना उनकी पीस खराब किया हुआ बिना, हम ये संपत्ति उन पर ट्रांसफर करें? तो अब आप में से कितने ऐसे लोग हो जिन्होंने मेरे चारों क्वेश्चन का आंसर हाँ करा है? जस्ट टाइप ऑफ 4 इन द चैट बॉक्स. जस्ट टाइप ऑफ 4 इन द चैट बॉक्स इफ यू हैव आंसर्ड ऑल माय 4 क्वेश्चंस एज यस. क्योंकि अगर आपने ऐसा किया है तो आपको एक चीज की जरूरत है, इसको कहते हैं एस्टेट प्लानिंग. क्योंकि एस्टेट प्लानिंग ही वो तरीका है जिससे कि इन चारों क्वेश्चंस का आंसर हाँ हो जाएगा, आपके लिए भी और आपकी आने वाली पीढ़ियों के लिए भी. और अगर आप सबने करा, इसका मतलब आप सबको इसकी जरूरत है. और मैं अगर ये चार क्वेश्चंस आपके किसी भी क्लाइंट से पूछूं, किसी भी क्लाइंट से, आंसर क्या आएगा? इफ आई आस्क दीज 4 क्वेश्चंस टू एनी ऑफ योर क्लाइंट, व्हाट विल द आंसर बी? यस. दैट मीन्स ऑल ऑफ देम रिक्वायर estate planning. That means all of them require estate planning. It is not a matter of economic situations, HNI है, ultra HNI है, common person है. No, they all require. It is not a function of family कि उनकी फैमिली मेंबर्स कितने हैं, किस लाइफ स्टेज पे हैं, उनका जेंडर क्या है. It doesn't matter. All of them require estate planning. All of them require estate planning because they want these 4 things to happen. चलिए. Do you know what is the purpose of estate planning? Estate planning का पर्पस क्या है, इसका रीजन क्या है? Why should you do your estate planning? Is the purpose to divide your wealth? Is the purpose to transfer your wealth? Is the purpose to give away your wealth? What's the reason? Is it really about wealth? क्या ये wealth के बारे में है? Actually, estate planning is not at all about wealth. ये wealth के बारे में है ही नहीं. ये wealth का मामला ही नहीं है. The real reason you should do your estate planning is not your wealth. It is the real reason is, are, and always will be people you love the most, whom you leave behind one day. इसका असली कारण वो लोग हैं जिनसे आप सबसे ज्यादा प्यार करते हो और एक दिन छोड़ के चले जाओगे. द रियल रीजन कैन बी योर चिल्ड्रन, मे बी योर स्पाउस, मे बी योर पेरेंट्स. दे आर द रियल रीजन्स. योर वेल्थ इज फॉर whom? आफ्टर यू. आपकी वेल्थ, आपकी वेल्थ आपके बाद किसके लिए? इनके लिए. तो हु इज मोर इंपॉर्टेंट, योर वेल्थ और देम? Never ever think I should do it because of the wealth I have created, AUM I have created, the business I have created. No, always remember it is for the people you love the most. You should do it. चलिए, अब मैं आगे चलता हूँ. अब मैं आगे चलता हूँ. I have created the need for estate planning somewhat in your minds. Now let me move ahead. Now I'll give you some concerns, and first I'll give you some family concern, and you have to tell me whether this is a concern or not. ठीक है, बताइएगा ये कंसर्न है या नहीं. पहला है, risk that your assets after your death might not fully pass on to your spouse, because if you die without a will, people other than your spouse are your legal heirs. So how many of you, we got 371 people or 380 people here, have created a will of theirs? Just type a Y if you have created a will of yours. हम में से कितने ऐसे नहीं, मुझे एन तो पता है सब है, मुझे वाई चलने हैं खाली. गुड. गुड, स्टिल गुड. तो क्वेश्चन इज, इफ यू डाई विदाउट अ विल, who will get your wealth and in what proportion, do you know? अगर आपकी मृत्यु बिना विल बनाए हो जाती है तो आपकी संपत्ति कैसे बांटी जाएगी, किसको मिलेगी और कितनी मिलेगी, ये क्या आपको पता है? आई एम टेलिंग यू योर लीगल हेयर्स, यू कैन नोट देम डाउन. एंड इट डिपेंड्स ऑन योर रिलीजन. इफ यू आर अ हिंदू, इट्स डिवाइडेड एज पर द हिंदू सक्सेशन एक्ट 1956, मुस्लिम सक्सेशन एक्ट 1937, क्रिश्चियन इंडियन सक्सेशन एक्ट 1925. इफ यू लिव इन गोवा, एज पर द गोवन सिविल कोड. right? So it depends on the religion or place where you live. So suppose you are a Hindu male. Parsis are governed by special sections in Indian Citizen Act. Okay. तो मैं आपको खाली एक एग्जाम्पल के लिए बताता हूँ. सपोज यू आर अ हिंदू मेल एंड यू डाई विदाउट अ विल. डू यू नो हु आर योर लीगल हेयर्स? आई एम टेलिंग यू, यू कैन नोट डाउन. ऑन द टॉप राइट द नेम ऑफ योर मदर इफ शी इज अलाइव. अगर आप लकी हैं और आपकी मदर अब तक अलाइव हैं, तो आप उनका नाम सबसे ऊपर लिख दीजिए. इफ यू आर अ हिंदू मेल, उसके नीचे अपनी वाइफ का नाम लिखिए इफ शी इज अलाइव. राइट द नेम ऑफ योर वाइफ बिलो इट इफ शी इज अलाइव. Below it, write the name of all your children who are alive today. Doesn't matter son or daughter, married or unmarried, minor or major, adopted or biological, sane or insane. बच्चा है, जिंदा है, नाम लिख दो एक के नीचे एक. Below it, if any of your child has passed away, leaving behind a child or spouse who is alive today, write the name of the child who has passed away. अगर आपके किसी बच्चे की डेथ हुई है, पर जिसकी डेथ हुई उसके बच्चे और स्पाउस आज जिंदा हैं, तो उस बच्चे का नाम लिख दीजिए जिसकी डेथ हुई है. काउंट करो कितने लोगों के नाम लिखे हैं आपने. जस्ट जस्ट काउंट कीजिए कितने लोगों के नाम लिखे हैं आपने. इन सब में आपकी वेल्थ बराबर इक्वली बांट दी जाएगी. ऑल ऑफ देम वुड बी डिस्ट्रीब्यूट योर वेल्थ इक्वली, और ऑल ऑफ देम वुड गेट योर वेल्थ इक्वली इफ यू आर अ हिंदू मेल. इज दिस सिस्टम ऑफ डिवीजन एक्सेप्टेबल टू यू? इज दिस सिस्टम ऑफ डिवीजन एक्सेप्टेबल टू यू? क्वेश्चन ये. और यू वांट फर्स्ट इट गोज टू माय वाइफ देन टू चिल्ड्रन? Or you want first to wife then to children? You have to tell me that. Because if you want it first to go to wife then to children, create a will. There is no other way to do that. Because this is the default. This is the default. So when you say by doing nothing, law will take its own course, that default may not be acceptable to you. And in no religion in India, your wife is the only legal heir. In Muslims, she gets 1/8 if there are children, and 1/4 if there are no children. In Christians, she gets 1/3 if there are children, and half if there are no children. So in no religion in India, wife becomes the sole beneficiary after your death. And you can overcome all of this by creating a will if you are a Hindu or a Christian. Muslims, it's a little different. They are not allowed to make a will of more than 1/3 of their property. So Hindu, I've just told, sir, I've just told, ma'am, Hindu male legal heirs are mother, spouse, children, and a dead child if their child or spouse is alive today, and equally among all of them. If you are a Hindu female, I'll just tell you, it is husband, married Hindu female, husband, children, and if any child has passed away, leaving a child who is alive, the child who has passed away, all of them equally. So this default might not be okay with you. That default is not okay with you. Now there are many reasons people give me for not creating a will, but I'll come to that. My question is, by what age should you create a will? By what age should you create a will? What is that ideal age to create a will? 40, 45, 50, 55, 60, 65. So let us do a small exercise by which you will come to know by what age you should make your will. एक छोटी सी एक्सरसाइज करने से आपको पता चलेगा आपको आपकी विल कब बनानी है. तो एक पेज पर अपनी डेट ऑफ बर्थ लिखिए. DD MM YYYY फॉर्मेट में। पहले डेट, फिर मंथ, फिर ईयर। हम जानना चाहते हैं आपको आपकी विल कब बनानी चाहिए। लिखिए, लिखा आप सबने? अब इसके नीचे, अब इसके नीचे लिखिए अपनी डेट ऑफ डेथ। फिर ये लिखिए अपनी डेट ऑफ डेथ। So when should you make a will? Before you die. And none of us know our date of death. So you should make it today. Today, today is the best day. Actually, you are lucky that you can still make it. आप लकी हैं कि आज की डेट में बना सकते हो, कि दुनिया में बहुत सारे लोग चले गए बिना विल बनाए। एंड हु हैज पेड द प्राइस ऑफ इट? इफ यू डाई विदाउट अ विल, हु विल पे द प्राइस ऑफ इट? पीपल यू लव द मोस्ट। पीपल यू लव द मोस्ट। राइट, चलिए आगे चलते हैं। एक और कंसर्न पूछता हूँ। हाउ मेनी ऑफ यू हैव माइनर चिल्ड्रन? आप में से कितने ऐसे लोग हैं जिनके बच्चे अभी माइनर है? Okay, good many people. My question to you is, in case both you and your spouse pass away while the child is minor, who gets the custody of your child? अगर आप और आपके स्पाउस की डेथ हो जाती है जब आपका बच्चा अभी माइनर ही है, तो आपके बच्चे की कस्टडी किसको मिलेगी, और आपके हिसाब से किसको मिलेगी? और मैं ये बता दूं आपको, ये आपकी पेरेंट्स को नहीं मिलेगी, मतलब बच्चे के ग्रैंड पेरेंट्स को नहीं मिलेगी। ग्रैंड पेरेंट्स वोंट हैव इट। Maternal grandparents won't have it. Your brother would not have it, her brother would not have it. Your sister will not have it, her sister will not have it. Because as per the Indian Guardianship and Maintenance Act, there are only three types of guardian. First is called natural guardian. And only parents can be natural guardian to a child. In absence of parents, society becomes the guardian of the child. And society is represented by the district judge. Now the district judge decides who gets the custody of the child. And such a guardian appointed by judge is called the certified guardian. But the problem is judges in India are very reluctant appointing individuals as guardian of the child. They prefer organizations over individuals. Because in an organization, there is a system in place which the judge can monitor for the well-being of the child. In house, there is no system, no process. And what do you call those organizations who take care of children whose parents are not alive? Call them orphanages. So would you like your child to go to an orphanage if both of you pass away? For that purpose, the law has a provision of a third type of guardian, which all of you should pay attention to. And it is called the testamentary guardian. Each parent is legally allowed to appoint a guardian of their child while they are alive through a document which is called letter of guardianship. If you have created this document, the custody of your child will only go to people mentioned in this letter. And no court or judge would have the authority to decide where your child would go after both of you, because you have exercised your legal right through this document. Please, please, if you have a minor child, create a letter of guardianship today and secure your most precious asset, your children. आपने उनको भी अनप्रोटेक्टेड छोड़ा हुआ है, अपनी सबसे कीमती पूंजी को आपने अनप्रोटेक्टेड छोड़ा हुआ है आज की डेट में. देन आई गिव यू अनदर concern. Risk of loss of information which you have. Risk of loss of information which you have after you die. Suppose आपकी डेथ हो जाती है. Now who knows who do you owe money and who owes you money? Who knows where you have kept your most important documents? Who knows what assets you own? Who knows where you have kept your keys to the safe locker? Who knows what are the user ID and passwords of your most important accounts? And even if you as couple know it, who after both of you knows it? Because you might both die in a simultaneous death situation. Have you created a system of passing information to the next generation? Have you created an asset information sheet or a death dossier? And make sure that this information only goes after death. If it goes before death, it can be cause of death also. ये देख लेना, ये डेथ के बाद ही जाए, डेथ से पहले गई तो कॉज ऑफ डेथ भी हो सकती है ये, राइट? चलिए, मजाक कर रहा हूं मैं, बट प्लीज एंश्योर यू क्रिएट अ डॉक्यूमेंट लाइक दिस. Then come some disability concerns. First is, if you become incapacitated, will your family members be able to access your wealth? सपोज मैं कोमा में चला जाता हूँ, मैं पैरालिटिक हो जाता हूँ, मैं मेंटली अनसाउंड हो जाता हूँ. अंडर सच सिचुएशंस, who would be able to operate your singly operated bank accounts, singly held mutual fund folios, singly owned properties which you have rented out? Who will be able to take rent on your behalf and renew the rent agreement? What have you done for that? And what can you do for that? For that, you can create a special document which is called springing durable financial power of attorney for incapacitation. I repeat the document name: springing durable financial power of attorney for incapacitation. It's the special power of attorney created for incapacitation planning, and it allows somebody to step into your shoes and do what you have allowed them in this document do with your assets. And I can put all the terms and conditions in the world in this document, that you can only withdraw money equivalent to 10 gram of gold every month from my account. Now it is inflation adjusted also. Right? So I can put conditions, and that are enforceable conditions. Right? Okay. Another concern. And for that, I'll give you a situation, and I'm sorry I'm giving you those situations. My job is such. And the situation we are talking about is, suppose you are brain dead, more than 15 days on a ventilator, and doctors keep you artificially alive. What's the risk? What is the risk? You are already brain dead, more than 15 days on a ventilator, no chance of recovering. What's the risk? First risk is you are in a lot of pain. Have you seen a terminally ill patient? Where all do they put the tubes? कहाँ कहाँ ट्यूब डालते हैं? Even looking at that person makes you feel the pain. सोचो जिसके साथ हो रहा है उसका क्या हाल होगा. And the second risk is your wealth is slowly lost to a doctor, nursing home, or a hospital. Can you do something about it? Yes. Can you do something about it? Yes. In March 2019, Supreme Court of India, in a landmark judgment, said, and I quote, right to die with dignity is the fundamental right of every Indian, unquote. And you can enforce this right of yours by creating a document which is called the living will. It's called the living will. It's called the living will. It's a document which which mentions conditions under which life support should be withdrawn from you, and it is legally enforceable. So I can create a living will where I say, if I am more than 10 days on a ventilator, less than 5% chance of recovering or surviving, switch off the ventilator, keep giving me painkillers, because आई रिफ्यूज टू रॉट ऑन अ बेड। मुझको बिस्तर पे पड़कर सड़ना मंजूर नहीं है, इसलिए मैंने ये डॉक्यूमेंट बना दिया। अब डॉक्टर की मजबूरी है, मशीन बंद करनी पड़ेगी, क्योंकि यू हैव अ राइट ओवर योर लाइफ। पैसिव यूथनेसिया इन इंडिया इज टुडे इज वैलिड। It's a legally valid thing in India today, and you can enforce a passive euthanasia by creating a living will, right? चलिए, अब मैं एक बहुत इंपॉर्टेंट डॉक्यूमेंट पे आता हूँ जिसको हम कहते हैं प्राइवेट फैमिली ट्रस्ट, राइट? आई एम अ फर्म बिलीवर that every Indian should have a private family trust, irrespective of age, wealth, etc. But because it's a little costly documents, many Indians cannot afford a private family trust, because to set up a trust you need 2.5 lakh rupees around money to set it up, right? तो किसी की वेल्थ अगर 5 करोड़ से ऊपर की वेल्थ है टोटल नेटवर्थ, तो देन आई थिंक दे शुड इनवेरिएबली हैव अ प्राइवेट फैमिली ट्रस्ट। तो मैं थोड़ी सी, क्योंकि वी आर शॉर्ट ऑफ टाइम, फ्रॉम स्मॉल वेरी ब्रीफ आई विल गिव यू अ इंट्रोडक्शन टू प्राइवेट फैमिली ट्रस्ट एंड व्हाई यू शुड फॉर्म इट। So what's a trust? Trust is a separate entity like from an individual. And what is a trust? Trust is a relationship between three parties whereby property, real, tangible or intangible, is given by one party called the settler to another party called the trustee for the benefit of a third party called the beneficiary. That means when A gives his property to B for the benefit of C, that arrangement is called the trust. See the beauty. B is the legal owner of the property, but not for himself, for C. That relationship is the trust. That relationship is the trust. मेरे पे प्रॉपर्टी है, मेरे लिए नहीं है, मेरे बेटे के लिए है। आई एम जस्ट द फिड्यूशरी। और आप लोग फिड्यूशरी बड़े अच्छे से समझते हो, है ना? फिड्यूशरी हो आप, राइट? तो फिड्यूशरी ड्यूटी है ये, ट्रस्टी की फिड्यूशरी। फिड्यूशरी ओनर है वो, रिकॉर्ड्स में उसका नाम जाता है एज ओनर, अपने लिए ओन नहीं करता, वो किसी और के लिए ओन करता है, राइट? यू नो, समझाने के लिए, जस्ट टू मेक यू अंडरस्टैंड, you know a company, a private limited company or a company is a separate entity than an individual. Likewise, a trust is a separate entity than an individual. In a company, the person who starts the company, they are called the shareholders. The same person who starts the trust is called the settler. वर्ड आता है सेटलर और ऑथर, उसे ग्रांटर भी कहते हैं कई कंट्रीज में, राइट? इट्स कॉल्ड ग्रांटर ऑल्सो। तो सेटलर बोलते हैं, इंडिया में सेटलर इज द मोस्ट कॉमन वर्ड। द पर्सन who runs the company day-to-day affairs is called the director. Same person becomes the trustee in a trust. जो रोजमर्रा की ट्रस्ट की जरूरतों का ध्यान रखता है, उसको चलाता है, उसको कहते हैं ट्रस्टी। द पर्सन हु रन्स द ट्रस्ट इज कॉल्ड द ट्रस्टी। अब कंपनी में all profit accrue to the shareholders. In a company, all profit accrue to the shareholders. Now there's a difference in a trust. Because in a trust, they can accrue back to the settler, the person who created the trust, or on the direction of the settler can be given to a third person. यहाँ पे डिफरेंट है कंपनी से, क्योंकि ट्रस्ट में आप ये पैसा कह सकते हो कि मैं ये पैसा दे रहा हूं आपको फॉर द बेनिफिट ऑफ समबडी एल्स। आपको मेरे निर्देश का, मेरे रिक्वेस्ट का पालन करना होगा। यू शुड हैव टू एनफोर्स माई रिक्वेस्ट। इफ ए गिव्स हिज प्रॉपर्टी टू बी फॉर द बेनिफिट ऑफ सी, दैट अरेंजमेंट इज कॉल्ड ट्रस्ट। अब इसमें एक चीज मैं और पूछता हूँ आपसे, कैन अ शेयर होल्डर बिकम अ डायरेक्टर? यस, that means a settler can become a trustee and the beneficiary, all three simultaneously, but he cannot be the sole beneficiary and sole trustee. बस यही एक वो है। ऐसा नहीं हो सकता मैं अपनी प्रॉपर्टी अपने को दे रहा हूँ खाली अपनी फायदे के लिए। ये हो सकता है मैं अपनी प्रॉपर्टी अपने फायदे के लिए दे रहा हूँ, बट ट्रस्टी दो है। नाउ इट्स वैलिड एज पर इंडियन ट्रस्ट एक्ट, राइट? राइट, तो चलिए अब हम रीजन देखते हैं व्हाई यू शुड क्रिएट अ ट्रस्ट। फर्स्ट इज वेल्थ प्रोटेक्शन प्लानिंग। तो मैंने आपको केस बताया था, है ना, son's wife took away 50% of the wealth. If that person would have created a private family trust, not a will, this entire property would have been safeguarded. Because the son's wife was divorcing her husband, not the trust. And the husband would have said, I don't own anything. Everything is owned by the trust. And I might be a future beneficiary sometime. Right now, I don't own anything in this trust. And this property would have saved. Second reason is estate planning and probate avoidance. Trust ensure inheritance because a trust cannot be challenged. A will can always be challenged. There is no will created in the world which cannot be challenged. Unchallengeable will के नाम की कोई चीज होती ही नहीं. विल कैसी भी बनाओ वो चैलेंज हो सकती है. ट्रस्ट को चैलेंज करना नियरली इम्पॉसिबल है. इफ आई आस्क यू वन क्वेश्चन, हु इज द बेस्ट एग्जीक्यूटर ऑफ योर विल, आपका आंसर क्या है? एग्जीक्यूटर जानते हैं? somebody who would enforce your will after you die. Your after death agent who has the legal power to enforce your will is called an executor. तो अगर मैं आपसे पूछूं आपके विल का बेस्ट एग्जीक्यूटर कौन है, तो कौन होगा आपके विल का बेस्ट एग्जीक्यूटर? यू योर सेल्फ. यू योर सेल्फ. आपसे अच्छा एग्जीक्यूटर आपकी विल का हो ही नहीं सकता. और ट्रस्ट में ये विल आपने अपने जीते जी एग्जीक्यूट कर दी. अब लड़ो, अब करो चैलेंज, अब तो मैं जिंदा हूं. वेरी डिफिकल्ट टू चैलेंज, राइट? थर्ड इज कंट्रोल एंड फ्लेक्सिबिलिटी. ट्रस्ट में यू कंट्रोल एसेट्स फ्रॉम योर ग्रेव. दोबारा सुनिए, ट्रस्ट में यू कंट्रोल एसेट्स फ्रॉम योर ग्रेव. विल इज अ वन टाइम प्ले. एक बार इंप्लीमेंट हो गई, जिसके पास गई, अब उसकी मर्जी चलेगी, आपकी मर्जी नहीं चलेगी, आपकी इच्छा नहीं चलेगी. तो वंस अ प्रॉपर्टी इज ट्रांसफर्ड थ्रू अ विल, द न्यू ओनर हैज एब्सोल्यूट राइट ओवर द प्रॉपर्टी. बट वन it goes through a trust, the trust is the owner, and all conditions of the trust are enforceable. So it gives me control over my assets after I die. I say this property should first go to my wife, who will only be able to live in this property or take rent from the property. But ultimately, it will go to my two children equally. I cannot do that in a will. I can only do it in a trust. Because in a will, the moment it goes to my wife, her will operates, and my will ceases to operate. You get the point? So control is there. I say my son will get 15-gram gold worth of money every month till he turns 30. That is enforceable in a trust. And at the age of 30, he'll get 20% of the corpus if he requires it. And this money would continue to be paid every month. At age 40, another 20%. So I am staggering the distribution of my estate, because sometimes you have to protect wealth for your children from your children also, right? That's very, very important words. Yeah? For your children from your children, right? Privacy and confidentiality. Trusts are totally confidential documents. There is something called security by obscurity. एक वर्ड यूज करते हैं हम, सिक्योरिटी बाय ऑब्सक्योरिटी. इसका मतलब क्या होता है? जो चीज आपके नाम के साथ दिखाई नहीं देगी, वो कोई आपसे नहीं ले जा पाएगा. है ना? पीपल कम आफ्टर यू टू सीज योर एसेट, सबसे पहले पता लगाएंगे आपके पास है क्या क्या. What is inside the trust doesn't show up against your name, so it is all saved. Privacy and confidentiality is very high in a trust, right? This I have already told, so I will miss that. Seven reasons why people are reluctant or hesitant to create a will. I'll just do that, or a estate plan. First is I am too young. Totally false. I don't want to think about death. Death is the biggest truth of life. I have only one child, so there won't be a fight over my assets. But you have to protect this wealth for the child, maybe from the child, and from the child's future relationships, in-laws, spouses, mismanagement of money. You still require an estate plan. Estate planning is expensive. The real expense is not doing estate planning. Your wealth gets destroyed. My estate isn't big enough to warrant an estate plan. Every person in this world requires estate planning. I have a estate of 50 lakh rupees, you have a estate of 50 crore rupees. For my children, my 50 lakh is as important as 50 crore for your children. What has money to do with it? It's a lot of work. I agree, it's a lot of work. But either you do this work or they fight over it after you die. I don't know why I need one. I've given you so many reasons. And my only end point at this stage is the biggest message is just do it. Just do it. Don't wait for tomorrow. Tomorrow will never come. Tomorrow will never come. Right? There are four documents which I told you all of you should have: a will, a letter of guardianship, financial durable power of attorney, and a living will. If you create all of them, you might leave an inheritance, not a mess. But please look at private family trusts. They are the place where magic happens in inheritance planning. All of you, I can say without any doubt, should have a private family trust. All your clients should have a private family trust. It's the ultimate way of inheritance planning. These are my contact details. We do inheritance succession planning for mutual fund distributors through the Next Gen Estate Planning Solution Company. We have a team of 20 lawyers and chartered accountants, and we do it online for you and your clients. Right? We create those wills, trusts, estate plans, non-resident Indian inheritance planning, and whatever you can think under the umbrella of inheritance planning, we do all of it on an arrangement of sharing with mutual fund distributors where we have a membership system. You can become member of Next Gen Estate Planning Solution, and where we will give free consultation to your clients. If you want to go ahead and explore how you can be assured with Next Gen Estate Planning Solutions, just WhatsApp to this number 9811033215. Just write Next Gen there, and we will ask my team to connect with you and tell you the details of how you can be assured with us. That's all from my side. I'm open to questions, and I pass it on to Gaurav now.
Thank you very much, Deepak Ji. I think it's so insightful. I myself was not aware about many things which you talked about. So I'm sure it is very, very useful for all our partners, and definitely when they are interacting with their investors, this is something a value add through this knowledge. Forget about anything else, but through this knowledge, I'm sure they will be able to add value to their investors. So we'll take few questions. I know we are going beyond the stipulated time, but I think we'll just take few questions because this is such an important topic and very valuable information which you have shared with the partners. So if you have any questions, please, partners, just post it on the chat window and we'll take few questions. I think you talked about the difference between the will and trust, and this is for the first time I also heard, but I think there are a lot of questions on it. Can you just briefly again, in 30 seconds,
So, see,
reshare?
will is a one-time enforceable document. It
Okay.
cannot be continuous. So, suppose I say first it goes to my wife, then to my son. Problem is, moment it goes to my wife, my will ceases to operate. Now my wife's will is enforceable.
Hmm.
So you cannot have a condition over a condition in a will, right? Second thing is, after it goes, I can't control it. So I say my wife is only authorized to take the rent on the property, not sell the property. Not possible in a will
Hmm.
because
Hmm.
it becomes an absolute property. So if you want control from your grave on assets, trust is the only way to do it. Third is, in a will, you make somebody the owner.
Right.
If there is a owner, their personal risks get attached to these properties. My son has a problem with his creditors. All the property which I gave to him becomes the creditors, it comes under the umbrella of the creditor. He
Oh,
has a problem with his spouse, it comes under the asset protection is zero. But suppose instead of will, I gave it in a trust. Now, in a trust, the title is with the trust. The son would say, I don't own it. मेरा है ही नहीं, मुझसे कैसे लेके जाओगे? मेरे को तो फ्यूचर में कभी मिलेगा.
so you can even transfer your financial asset to the trust apart from physical assets, any kind of
It's
assets.
easier. financial assets. See, people ask me how can I transfer my mutual fund to a trust while I'm alive.
Hmm.
तो बड़ा आसान है, उसको डीमैट कराओ, ट्रस्ट का डीमैट अकाउंट खोलो, ऑफ मार्केट ट्रांजेक्शन से ट्रांसफर करो, रिडेम्पशन होगा नहीं, सेक्शन 47(3) में कैपिटल गेन नहीं लगेगा,
Oh,
राइट, सेक्शन 56 में गिफ्ट टैक्स नहीं लगेगा, तो बिल्कुल टैक्स फ्री जा रहा है।
wow.
और अब वो सेफ के अंदर लॉक हो गया, वो निकाल ही नहीं सकता कोई आपके बिना पूछे, चाहे कितने क्रेडिटर हो, सेपरेटिंग स्पाउसेस हो, कुछ भी हो, इट इज ऑल सिक्योर्ड। अगर आपके बच्चे इंडिया से बाहर है, एनआरआईज,
Hmm.
उन पे
Hmm.
इनहेरिटेंस टैक्स है, ग्लोबल टैक्सेशन है, बड़ी प्रॉब्लम है। आप देखे क्यों जाते हो उनको, ट्रस्ट में डाल के चले जाओ, वो लगेगा ही ना, इनहेरिटेंस टैक्स लगेगा ना ग्लोबल टैक्सेशन लगेगा ना। वैसे भी मतलब इनहेरिटेंस टैक्स को ऑप्शनल टैक्स बोला गया है वर्ल्ड वाइज, कि जो प्लान नहीं करते वही पे करते हैं, जो प्लान करते हैं वो कभी पे नहीं करते उसको। आई कैन गिव यू हंड्रेड्स ऑफ यूज केसेस ऑफ अ ट्रस्ट। एक ट्रस्ट
Wow.
होती है डॉटर प्रोटेक्शन ट्रस्ट।
Hmm.
तो हमारे
Hmm.
कुछ क्लाइंट्स ऐसे होंगे जिनकी डॉटर्स होंगी, सिंगल डॉटर्स और मैनी डॉटर्स, और पेरेंट्स की एक बहुत बड़ी वरी ये है कि हम दोनों के बाद जब डॉटर ओन करेगी, हर इन लॉज और हस्बैंड कैन इन्फ्लुएंस हर एंड टेक दिस वेल्थ।
Correct.
अब डॉटर के लिए प्रॉब्लम क्या है, अगर वो मांगते हैं और वो मना कर देती है, तो उसकी रिलेशनशिप खराब हो जाती है,
Correct.
ऑल्दो
Correct.
लीगली, राइट। और दे देती है तो प्रॉपर्टी खराब हो जाती है। मैं उसको ट्रस्ट में प्रॉपर्टी देता हूँ जहां उसे अलाउड ही नहीं देना, तो वो कहेगी मैं देना तो चाहती हूँ मेरे, पर मेरे पापा ने कंडीशन ऐसी डाली हुई है ट्रस्ट में कि नहीं दे सकती, तो पापा विलेन बने ना, मैं तो बच गई।
I think this is a very good use case in terms of, the various benefits of having trust. So this is very useful. Very useful. Thank you for it. Uh, Also, what is the difference between the will? Means, I have made a nomination, but there are questions which are coming is that, okay, if I made a nomination, is it something then
So,
will is
so,
still
so,
required?
let me see. As per law, nominee is not the owner of the funds.
Okay.
Nominee is just the caretaker and distributor of the funds legally. That means
Okay.
I have a mutual fund folio of say 10 lakh rupees, which is in my name. My wife is the nominee. After my death, these units would be transmitted to my wife because she is the nominee. Not to own, but to
Hmm.
distribute. And
Okay.
while distributing, she has two options. First option is if I had a will. If I had a will, as per instructions in the will, she'll have to distribute. And if there is no will, she will have to distribute to all legal heirs of mine as per law.
Even I have the nomination.
Even because nominee is not the owner. There are
Wow.
only two products in India where nominee is the owner. First is life insurance policy, because
Hmm.
we amended the section 37 of the Insurance Act in the 2017 Insurance Amendment Act, and we introduced beneficial nominee there. Because of that, my parents, spouse, and child become the owners. And second is PPF, right? PPF also the nominee becomes owners.
Okay.
Apart from that, no product in India nominee is the owner. Same is for joint accounts. People think I have opened a joint folio, either
Hmm.
survivor.
Hmm. Hmm.
So survivor becomes the owner. No. Law says if an asset is jointly owned, it is equally owned. 10 lakh rupee folio, 5 lakh is mine, 5 lakh is my wife. Whether I am the first holder or second holder doesn't matter.
Okay.
After my death, my wife will have to distribute my 5 lakh rupees to my legal heirs. Because either a survivor you pick where? Mode of ownership or mode of operation.
Hmm.
It's
It's
only
a mode of
operations.
operation.
Yeah, so those are misconceptions people have.
Correct. No, absolutely. I think these are very, myths which have been there, and thanks for, clarifying it. I think very, very useful. Uh, so I think one question is that, okay, will MFD lose his AUM when the client transfer his financial asset to the trust?
No, doesn't matter. Whether
Hmm.
it's owned in unit form or demat form, you are still the ARN holder.
Yes,
Doesn't matter, na?
correct. Doesn't changes, in terms of the
Yeah.
distributor. Okay. And can you also, while you talked about in detail in terms of various type of wills which have been required, asset information sheet which you talked about, financial POA you talked about, living will, very interesting concept which you talked about. But what are the common mistakes? Because you have helped so
See,
many investors. What are the
so
common three, four mistakes
first
which
thing is
need to
people
happen?
don't accept that they are going to die. That's the biggest mistake people think,
So they
right? I
postpone
will
that.
not,
Yeah.
they keep on postponing, right?
Correct.
Tomorrow, and that tomorrow never comes, right? Second is, you don't make a list of your assets completely. You leave things
Hmm.
out, right? You create a beneficiary, don't create a successor beneficiary. It goes to my son, but your order of death, I don't know. All things can happen in the world. So you should have all alternatives, what can happen in the world, incorporated in your will.
Hmm.
My son can die before me. My children, all children can die before me. My son can become incapacitated in front of me. So I become incapacitated. Now, all of these things should be there now. You have to build in those scenarios and say this is the ideal thing that should happen for me.
Correct.
Right? So that scenario building is there. And one thing which I always tell people is, in inheritance and estate planning, there are certain things which you know that you know. Then there are certain things which you know that you don't know. And lastly, there are certain things which you don't know that you don't know. That last one is the most risky one. And for that, you need a professional advice. It's not a do it yourself world, because it is dealing with your entire inheritance.
Inheritance.
You
True.
have that 30, 40, 50 years of your work is that what this person is operating. Any mistake there would be very costly for that next generation of yours.
No, absolutely, you're right. And I think for the entire life you're working in creating those assets, and it,
And Gaurav, one
in
more
absence,
thing.
yeah.
Many of us have spouses who are 3 or 4 years younger than us, and
Correct.
they will live at least 10 to 15 years more than us. So one day your spouse would have the obligation of managing this wealth.
Hmm.
And if you are not training them for this, you are doing the biggest mistake of your life. That
Correct.
female financial literacy, it is your job to make them financially literate. Nobody else from outside would come and do. Whatever wealth, if I leave from my wife, if she doesn't know the difference between a current and saving bank account, doesn't matter how much I leave for her.
Correct. Correct.
So it's not giving, it's making them ready to accept that and operate that. That's very important.
No, I think absolutely this is a very important point you touched here. Also, there is one question. If a client has made a will and added all the existing folios, what will
Hmm.
happen if they add new folios in the future? Will they have
So,
to
sir,
keep changing the will?
for that purpose, we have a residuary clause in the will,
Okay.
which says whatever I have not mentioned in this will, it
Hmm.
will go to this person.
Okay. Okay.
The
Okay.
residuary is the what will take care of it.
Hmm. Sure. Okay. And does siblings have any right over the property in case me or my
In
wife is
case there
not
is
there?
no class one legal heir, the heirs which I told you,
Yeah.
then it goes to father. People don't ask me why father is not there in the list.
Yeah, yeah, yeah. Correct, correct.
फादर को कुछ नहीं मिलता,
अच्छा,
राइट? क्योंकि हिंदू फादर का एक ही काम होता है, लो
देने का.
लेने
हाँ,
वाला काम नहीं होता. बट
correct.
इफ फादर इज नॉट देयर, देन इट गोज टू ब्रदर्स एंड सिस्टर्स
Okay,
इन
okay. And in
हिंदूज.
case of mother, how does that,
मदर, द
in
लीगल
case of
हेयर ऑफ
Hindu
अ हिंदू.
female, how does that,
So Hindu
work in
female,
terms
if
of
she is
the,
married,
hmm,
then husband, children, and if there is a dead child who has child alive, the children of the dead child.
okay.
If none of them is there, then it goes to legal heirs of the husband,
Hmm,
then legal heirs of father, then legal heirs of mother.
okay. Also, very interesting question. Like as a distributor, for distributing mutual funds, you need an ARN, or for SIF, you need to clear the exam. For PMS, you need to clear the exams. So, is there any, if somebody has to work in the areas of trust, will, and estate planning, is there any certification, or how does that work?
So there is no legal requirement of a certification.
Okay.
Okay, but we have a certification called Chartered Trust and Estate Planner (CTEP), which prepares you for this, and it is created for FL managers only.
Okay.
See, this estate planning is a combination of three things.
Hmm.
One is you should have some legal knowledge, you should have good knowledge of wealth, and third is relationships.
Correct.
So other two you have. I just want to add that legal bit to you, and you become a very good estate planner.
Oh, okay. Sure. There are a lot of questions on because there are a lot of distributors, those who have NRI kind of clients. So what they
Right.
wanted to check if NRI person have any property in India, how they can create will or, in terms of trust, or for parents, those who have NRI children.
So very easily it's created. I have to check the FEMA laws only. And FEMA law is applicable not on the Indian citizen, it is more applicable on the foreign citizen when they want to
Okay.
gift it to India.
Hmm.
Indian citizen, the FEMA laws is what can be repatriated, right? So there are some restrictions on it, but creating a trust is always possible, and it will be better for that NRI, whether he has children around, outside India or he himself is the NRI, to create a trust in India. This trust holds property not in direct names. That would make it easy for the children and NRI's children to inherit this wealth after him with
Okay.
least amount of taxation.
Sure. No, I think this is, such a wide subject, and I'm sure our partners will have host of questions. I think there is one comment from one of our partners, and he rightly says this is only tip of iceberg. But and its subject is so vast. Deepak ji has shared his details. You guys, you can contact him and his organization, and they have the entire setup to really help the partners. Our objective at Canara Robeco was, of course, to kind of give you some insights around this subject, and to introduce you to one of the professionals, and of course you can reach out to him. As he said that, okay, he has been doing a lot of sessions for the clients. You can take his advice, or take his in terms of attend those sessions and can benefit out of it. But thank you very much, Deepak ji. It is so insightful, such an important topic. I think in our routine things, we really forget and missed such a high priority item, which should be actually at the top of our priority. We don't give enough attention to it. So thank you for bringing all these important perspectives to our notice of our partners, and I'm sure it is very helpful to them, because it will help them. These insights will also help them to interact with their investors, and they will be able to add value to their investors. So thank you very much, Deepak ji. Thank you
So
very much
thank
for
you.
this
Thanks.
session.
Thanks. Thanks.
Thank you.
Thanks. Thank you. Thanks. Bye.
Mutual fund investments are subject to market risks. Read all scheme-related documents carefully.